All righty. It is my absolute pleasure to be back with you. I had surely looked forward to this weekend in New England, but as we know, that didn't happen. I want you to feel that you can ask me anything, but because the topic is sensitive, if it's not something you want to share in chat at the end, I am available, and my email address is at the end of is in the last slide. All right. What we're hoping to accomplish here today is to give you a level of confidence to deal with your clients who may be prescribed with cannabis for treatment or choosing to use it where it is lawful. And we know that our practice is governed and controlled by a variety of bodies. So we look at all the codes that affect us, but underlying all of that is the law. And that depends on where you live and the tenets and philosophies of ethics, which we are all bound to. Now, we all know that there's a variety of law, and that clearly federal law is at the top of the list and everything else comes secondary. And the reason for that is the concept of preemption. It comes from the Constitution, from the Supremacy Clause, and it is the reason that federal law supersedes state law, which supersedes local law. But it all comes down to professional responsibility when we're talking about case management. Now, depending on your underlying licensure, state laws require that you have a certain level of education, standardized testing, money, of course, and that there are continuing education credits that are required to comply with the licensing requirements, and that you must comply with all of the state's laws. Under the paradigm of case management, it really is the same concept because the same demands are required of us. There are a lot of good sources when you're looking for how am I guided ethically, how am I guided as a case manager. Well, CMSA has the standards of practice and also has the Professional Case Management Journal, which is a juried journal and, at the highest standard of scientific information. So those are good sources, as are many others. And depending on your underlying license and certification, you're going to be guided by the one that controls your particular practice. So there's all of these rules, and do they conflict? Well, we're going to be looking at a place where they absolutely conflict today, but what they all agree on is that case managers should be in compliance with all laws, regulations, and standards. And the citations below are for the nurses and for case managers. And if you look at the AMA, pharmacists, physical therapy, you name it, they all agree on this one point. So CCMC has a code of professional conduct for professional certified case managers. However, if any of you are hanging out tomorrow to join us for the mock trial, you'll see that it is our legal opinion that even if you're not certified, you should be aware of the requirements of the code of conduct for certified case managers. And it's because it's a known standard, and we'll be dealing with that tomorrow as well. So legal compliance requires that we're knowledgeable. If you are a certified disability management specialist or work in trying to get folks back to work, no matter your title, you're going to want to know what the disability management requirements are, and they're all the same. Knowledge and act in accordance with state and federal and local law. The CMSA standard of practice goes one step further, and the word shall, which I argued for quite a long time, was put in there. And that tells the world that as case managers, we will comply with all laws, rules, and regulations. So that takes us to our problem. Now, if some of you are, 60s music buffs or old like me, you may remember Grace Slick and When the Truth is Found to Be Lies. Well, that's where cannabis law begins. In 1970, President Nixon signed into law the Controlled Substance Act. And at that time, Schedule I read as you see, that examples were ecstasy, LSD, heroin, marijuana, should all be considered Schedule I, which means they are the most dangerous drugs. And even though since that time, there has been demonstration of the medical benefits of cannabis, which is why many of the states have now incorporated into lawful medical practice. So, signed by Nixon in 1970, we sit here 51 years later, and this remains the law of the land. Now, in 2016, Congress had toyed with reclassifying marijuana as something other than a Class 1. That's all it would take to eliminate this compliance problem. By categorizing marijuana as Schedule I, it is declaring that it is the most dangerous, and nothing has changed in the law in 51 years. Now, we know that the states have changed them a great deal, and the most recent changes this year have been an addition of Connecticut and New York, New Mexico and Virginia. Alabama has legalized medical cannabis this year, but not for recreational use. And Louisiana decriminalized an amount up to 14 grams. Back in the day, we had a drug possession case that went before the court, and my partner used baby powder and put it on a black piece of construction paper to get the officer to testify how much a certain number of grams looked like. Well, let me be sure to tell you that nobody knows, and it's a very small amount. So places that use the gram measurement, it's very difficult to show that the person had more or less or the legal requirement. So the reason that it is so important to recognize that federal law is still in control is the potential consequences. Now, for simple possession on a first offense, there is a maximum jail term of 2 years and a minimum of 15 days. Federal sentencing has mandatory minimums, and these are them for controlled substances. If it is a multiple offense, we're looking at a minimum mandatory jail sentence of 90 days with up to 3 years. And this was redone in, I think it's 2018 or 16. You can see the slide better than I can right now. But this is not old news. This is current news. And the Attorney General of the United States could, on any given day, choose to enforce it. Now, under the present administration, no one expects that to be the case, but we also don't know if there's going to be a change in the foreseeable future under federal law. However, Justice Thomas, who I often don't agree with, led the opinion on this particular case. And this was a case where Colorado, which was one of the first to legalize marijuana for recreational use, there was a case brought about a dispensary. And by refusing to hear that case and the way the court responded, these are Justice Thomas's words. He said, it's time for the federal government, the Olympics, so you can see the time frame of when this was coming out, because the Olympics has now been struggling with whether marijuana is a performance altering drug, and it's hard to believe that it would improve anyone's performance. He went on to say that it's here to stay, notwithstanding those, himself included, who have misgivings about whether it's the wisest course. There are 18 states and the District of Columbia that have legalized it for recreational use. Continuing to put marijuana in the same category of dangerous and illegal drugs as heroin, ecstasy, and LSD makes little sense. And that is a quote from July 9th in the Washington Post from Justice Thomas. So the question is, you know, if the court gets the right case, will they do something about it? And right now, by refusing to hear cases, they are allowing the states to be independent and do as they choose. Now, this is a recent map from July of those states that have in green legalized. In yellow have approved medical and some decriminalization. Blue is medical use only. And you can see that Massachusetts and Maine have, New Jersey, all the green ones, have legalized. So what does that mean to us? Well, here's some of our conflicts. If one is controlled and is, by CCM, by being a certified case manager, but also by being a licensed nurse or other professional, we have an affirmative duty. If anyone is possessing knowledge, not protected by confidential status, to report on each other. So if I walked in to an office, a case, even online, and there was a way for me to realize that my colleague was either intoxicated or under the influence of marijuana, and that person's behavior was altered in such a way that it was dangerous for the client that they were dealing with, we all have an affirmative duty to report such behavior. But remember that your state licensing authorities have an interactive mutual relationship with the case management, with the commission for case management. It's true for all of the other certifications as well, and it's true for our licensing authorities, that there is this obligation that if one of us is impaired, we have an affirmative duty to report. And here's where it shows up in the Certified Disability Management guidelines. It shows up that board certified disability management specialists having personal knowledge concerning a violation have a duty to report. And the same language is similar throughout. Now, the American Nurses Association, for those of us who are nurses, have divided their standards of practice into three components: the professional standards, the professional performance standards, and the specialty practice standards. So under the professional performance standards, if a nurse identifies that another nurse is impaired, they too have an affirmative duty to report it to the appropriate authorities. And this is heavy duty stuff. So the scenario is, well, I have a prescription, I receive medical marijuana for some approved qualifying condition. It's been given to me by a physician, and then I go and work in a arm's length patient situation. Where does the law stand on this? And the answer today is we still don't know. All we can do is rely on our ethical choices and that are guided by the standards. And we are, as all case managers, guided to behave and practice in an ethical manner, adhering to the tenets. Now, I'm not going to read them to you. You've seen them a million times before. But if we are not going to do harm, which is one of the things that we are bound to, if we are going to treat our clients and patients fairly, can we do that if we are impaired? And the question is, by how impaired is impaired? If I use something today, we know that it's going to stay in your system for up to 30 days. What we don't know, and they're still developing a test, like a breathalyzer type test, is how much in the system causes a level of impairment. If one is stopped, and we're going to look at a scenario in a minute for that, if one is stopped on the road and arrested for driving while impaired, the existing tests at today only show a presence or a lack of any particular drug, including that of marijuana. So the question is, how does one, deal with that in the real world? All of the ethical codes of conduct agree on our duty to act ethically and to be in compliance with all laws. So what about the ethical dilemmas that all of these conflicts create? Well, by definition, an ethical dilemma is simply a situation where there are two choices or more to make. And, by what body of knowledge, what system of ethics do you make those choices? One of the hardest things to do when dealing with an ethical dilemma is to determine what that dilemma actually is, and then what your legal and ethical obligations are. Well, we know we have to comply with the law, and here with the scope of practice. So not only are we worried about the standards of practice and the laws that govern us, we also have to look at the scope of practice. If one is a nurse versus an advanced practice nurse, there is a distinction. And we are all bound to adhere to scope of practice and standards of practice, and to demonstrate critical thinking. That's when we let them know what we're thinking, so that when our choices are scrutinized, we have a good source to rely on to defend ourselves if we have to, or to go back and reflect on information that happened some time ago. Checklists may simply not be sufficient. Clear, accurate documentation that tells someone what you were thinking when you made that decision is going to be your strongest defense. So I bring up the issue of delegation because the American Nurses Association in particular has come out strong on what we can delegate, to whom we can delegate. And this is not just in the clinical setting. It has to be the right task, circumstances, and person to be delegated to, and the right direction and communication. There also is an ongoing duty of supervision and feedback once there is a delegated task. And the link that I've provided you with gives you the national guidelines from the American Nurses Association, or you can find it on the website for the National Council of State Boards of Nursing. They've come out with a good document to give you guidelines. And the reason that this is important is we have yet another conflict. We have states that are in the Nurse Licensure Compact, where licensed practitioners are required to know the law in every state in which you practice. So if you are a compact nurse and you're practicing, whether it's in person or telephonically or virtually, to another state, you have the duty of knowing what is lawful in the distant state. So, example, Connecticut has just legalized marijuana, but is not a compact state. So if you are licensed in Connecticut, or if you, well, you'd have to be licensed in Connecticut if you were dealing with that person, but you might be duly licensed. When I was actively doing field case management, I was licensed in New York, New Jersey, and Connecticut. I've let Connecticut go, but I still maintain my New York and New Jersey RN licenses. So you must be licensed in the state in which you practice. But if you are in a compact state, that increases your duty because it increases the number of states in which you may practice. The biggest difference between the states is medical marijuana versus recreational marijuana. And when we look at medical marijuana, what are the qualifying conditions? Now, each state has decided through their legislative bodies what the qualifying conditions may be and who can prescribe the medication. So if you lay the map of lawful marijuana use over the compact map, you'd see that there are great inconsistencies between the two. So those qualifying conditions, you're probably generally familiar with them, but this is just a generic chart of ones that might be considered qualifying in the state in which you practice. You have to know what your individual state considers a qualifying condition for someone to obtain medical marijuana. So there's been a lot of talk about decriminalization, or is it still a crime? Well, a crime or felony is defined by a prison sentence of more than a year in jail. So if one possesses more than an ounce, and this is general for the states that have legalized it, an ounce, or in Connecticut, that 14 grams, which is just under an ounce, use and sale and underage possession are still criminal behavior, right? And there's still serious consequences associated with them. Driving under the influence is not an exception anywhere. So even if your client is receiving medically prescribed necessary marijuana treatment, they still can't get behind the wheel and expect to operate that vehicle without any potential consequences. So what does decriminalization look like? It is typically possession of marijuana up to an ounce, but it also is a person who is 18 or older. There is no legal marijuana use for somebody under 18 in any of the states that have legalized it. It's punishable by a fine, but the big difference is there is no jail time and no criminal record. That's what decriminalization looks like. Fines could be a lot of money, but there will be no jail time and no criminal record. Now, the states have treated possession while driving very differently. In Massachusetts, there's driving, having possession while driving is a license suspension for a period of 6 months. And some states have specific, what they call drugged driving laws. Most states have DWI, which is driving while intoxicated, right along with driving under the influence, and treat both alcohol and being under the influence the same. Possession of paraphernalia, those things associated with the use of marijuana are just there can be a mere possession. It's not a violation, and there's clearly no criminal record for that. So things have changed, but not that much. So let's do a little scenario. John and Mary love camping. They live in Pennsylvania. They spent the weekend in a remote site at Baxter State Park in Maine, a beautiful place. John's a trucker, Mary's a CCM. Marijuana is legal in Maine, and they had a great time. On the drive home, they're stopped on the Pennsylvania Turnpike, a terrible road, oh, by the way. They were found to be in possession of 10 grams of cannabis. John is charged with driving while under the influence. There goes a great weekend. So you always have to consider, if you're talking about yourself or if you're advising a client, that there are conflicting laws that even though it might be legal for your client to have, possess, and use medical or recreational marijuana, depending on the state, that's not carte blanche to do anything they want, particularly operating a motor vehicle or professional practice. There is no exception in any state that I can find that if medical marijuana was prescribed for me, let's say, and I am practicing as an attorney, or I'm using my license and practicing as a case manager, if I am under the influence of marijuana, there is no exception, and that is going to be found to be inappropriate and unlawful practice, and one could very well lose their license, either temporarily or permanently. So many of you are in Massachusetts, but that's not the only place that you are today. I tried to look at sort of what do the neighbors think about all of this. The bottom line is that hemp and marijuana are both cannabis. And the distinction is one of law, not botany. Marijuana is illegal if it has more than 0.3% of THC by dry weight. And according to the 2018 Federal Farm Bill, hemp is legal if it has 3% or less. Why do we care? Because more to the point, THC is what gets one high. Hemp and CBD do not. In New Hampshire, there is no specific drug driving law. Therefore, the driving while under the influence would apply. Pennsylvania, where our scenario would take place, has specific cannabis drug impaired driving laws. There is zero tolerance for THC. For states without that specific per se drug driving law, it is based on the existing driving while under the influence, and successful prosecution depends on documented behavior. So if one stopped, the observations that an officer makes about behavior, dilated eyes, can't stand straight, speech slurred, those things that would apply if it was alcohol intoxication are applied similarly in those states that have a drug driving law. So, case management assessment. When you have that initial contact or two with your client and you're going to determine what their needs are, how you play into their needs. Well, you have the medical status, their diagnosis, including medications. So you're going to want to know not only what they're getting by prescription or over the counter, but what about other herbal therapies, or where it's lawful, their choice. We have to treat cannabis, like any other medication that our client might be taking, because it has drug interactions with other substances that a physician or advanced practice nurse might prescribe. Their cognitive and behavioral status is part of our assessment, and their client goals, their functional status, their needs. I mean, we all know what a case management assessment looks like. We also have to consider their beliefs and values, faith-based choices, and other things that affect who they are and what their choices are. The ethical decision-making process incorporates the principles of ethics. The most important is that we want to let our clients be autonomous in their choices. We want to support them and understand and maintain their individual character, values, and uniqueness regardless of our personal opinion. When we act as case managers or other health professionals, we don't have the luxury of imposing our personal opinion on our clients. Sort of check it at the door, if you will. We have an obligation to do the best that we can, and the client can expect that the case manager is going to make choices that benefit that client. So we can't allow any personal beliefs that we have to flavor the choices that we make. Whenever we're doing ethical decision making, we also want to consider that our client has the freedom to function independently to the best of their physical ability and be able to make decisions on their own. We want to treat all of our clients fairly, taking into consideration where we find them, their socioeconomic standing, race, creed, sexual orientation, faith-based beliefs, or anything else that is part of that client. It's not our job to judge. It's our job to incorporate our choices in assessing and planning to what our particular client's needs are. And always to avoid harming our client in any way. And in my opinion, that includes trying to impose our beliefs on that particular client. So, you conduct a home visit, whether it is in person, telephonic, or video virtual. And as part of your assessment, you ask the client what prescription meds, over-the-counter, vitamin supplements they're on. And then you say, is there anything else? The client proudly shows you his or her meds, including cannabis that they receive from either a doctor or a buddy. And how do we treat that information? We report it accurately as it is shared with us by the client, because that's what they're putting in their body. And it is critical as part of our case management assessment that we have a full knowledge of what's going in their body because of potential drug interactions. Something as simple as the mixture of alcohol and marijuana. One of the downsides of marijuana use is that when it's combined with excessive alcohol intake, it takes away the nausea and potential vomiting that would keep someone from overdosing on the alcohol. When you hear about unintentional drug overdose or alcohol intoxication and poisoning, it is typically because this combination takes away the body's self-defense of ridding itself of the excessive alcohol. So it would be important for the doctor to know what our client is ingesting wherever it falls on the legal spectrum. So I leave you with this one. If your client doesn't qualify for medical marijuana under the state's law, can't you just say in those states where recreational marijuana is available, you can just go down to the dispensary and get it yourself? No, because that is beyond your scope of practice. That would be prescribing. And even though it's prescribing something that is lawful and available to the general public, you can't go outside your scope of practice and prescribe. So what else do you need to know? As in real estate, it's location, location, location. You have to know the state in which you're practicing. You have to know what it permits and what it does not. You have to know whether or not you're in a compact state and what your duties and obligations are if you do hold a compact license. And is it prescribed by some health practitioner or the patient's self-help? Both are important, and both are important to share with those who you're reporting to so that they can best help your client get to the best point of wellness that they can achieve. Now, for those who work in the workers' compensation area, this is a danger zone, because if you become aware that your client is using marijuana, it may impact their ability to return to work. But I believe that honesty is the best policy, that our case management assessment and other records must be true and accurate, whatever the consequences. But I do caution you always, when you have that first contact with your client, no matter where you're working, you have to make them aware when you obtain consent for case management services that you will be sharing that information with third parties. Depending on the type of practice, it could be a variety of people, from the physician to other therapists, to the employer. It could be a variety of people, but you have a duty to be open and honest with your client when you accept them as a case management client, to make them aware that information that they choose to share with you is going to be shared with somebody else. So you need to know where you are and remember the law that applies to you. So how do you protect yourself? I mean, that's most important. Well, you have to know the law in the state or states in which you practice. I think I've said that probably 12 times already. And you have to, one of the easiest ways to do that is to check with your state licensure website, minimum 4 times a year, once a month if you're crazy like me. Nowadays, with all that's going on with COVID, the front page of those state licensure websites will be full of the policies and any change that's going on right now with COVID. But it's also going to show you any new laws, rules, and regulations that that state is imposing, or letting be more generous, if you will. And your best friend always is document, document, document. Let them know what you're thinking. This is the link to the National Council of State Board of Nursing marijuana guidelines, which is extremely helpful. The most common qualifying conditions, and again, these are going to vary very specifically state to state, are the ones that you would expect. Cancer, glaucoma, hepatitis, neuropathy, Parkinson's, a variety of diseases that cause persistent muscle spasms. One of the most effective uses of medical marijuana has been for young children with severe seizure disorder. Here, where I am in New Jersey, there was a child who had never spoken and who could not attend school because she was having seizures up to 18 and 20 times in an hour. Long story short, fast forward, she was able to use cannabis oil. Her mother had to go to the school because the school nurse was not permitted to administer at that time, and the child was functioning effectively and age appropriately in school. So there are very good uses for medical marijuana, but we are still in a position of this is a developing field of not only law, but medicine. I've shared with you in the handouts here sources and references for your benefit, and some practice tips, because that's always important. When you're confronted with crazy, just take a breath. In our practice, we are confronted with crazy all the time. If I open this up, you'd all have a story. But to me, and my new mantra has become, know your client. Every client that we encounter is different. Everyone has unique needs. No two 45-year-old white females with the same diagnosis are the same, or any other combination of age and other characters that you come up with. You have to know this client today and how you can work best with them and for them, and really to understand what their needs are. Read peer-reviewed journals. I suggest you avoid blogs that have either a political or commercial agenda. You can read them for information, but understand that if you scroll down to the bottom of these pages and see who's putting the information up, it may or may not be something that is appropriate for you to rely on in your professional practice. Self-educate. I mean, you're here at a continuing education conference, so I am preaching to the choir. But you know, any information that you can get a hold of. I get the New England Journal of Medicine every week. Gives you a blurb, tells you what's going on, but be careful of texts, and you want to be careful that you're on legitimate websites that don't have some commercial agenda. They're not trying to sell you something. And the most important one to me is the old phone a friend. There is absolutely nothing wrong, and I would salute you for encouraging you to collaborate with your colleagues and other health professionals that you deal with. To say to, let's say, a physician, I've just never dealt with this particular diagnosis before. Is there anything I need to know to best work with my client? Who's going to criticize you for that? So it's really important that, you know, you collaborate with colleagues, you collaborate with other professionals, and never ever be afraid to ask a question. I think it says more about your character than it would to say less of you. So there we go. And I thank you very much for your time. If there are questions, I will do what I can. Okay. That's okay. Have a good one.
Hi, Lynn. I don't see any questions in the Q&A. Does anybody have any questions?
If not, here we go. Good.
Just always excellent to hear you speak.
Thank you.
Well, thank you again, Lynn. Before we end day one of our conference, Maureen has a few housekeeping items to go over with people.
Thank you again, Lynn, and thank you everyone for joining us today. So we have ended a little bit early, which probably is nice after sitting in front of a computer for the last almost 4.5 hours. So I just have a few reminders for you. When you, I'm stumbling over my words. If you are registered for tomorrow's session, you will receive a special unique link to join on tomorrow at 11:30. So if you haven't received that already, and I know you've probably received all kinds of reminders from Zoom and us, give me a call in the chapter office either this afternoon or tomorrow morning, and I'll make sure that I resend them to you. Remember, when you're leaving this session this afternoon, that you do so by the red either leave or end button in the lower right-hand corner of the screen. This will take you to a Zoom screen, which has a blue button in the middle that will tell you to continue, and you can continue on to the evaluation link from there. Please complete the evaluation as soon as possible so that I can get your certificates out to you. And make sure you put in ideas for speakers, sponsors, topics that you want to see offered by CMSNE so we can really meet your needs. The last thing is we'll be pulling our scholarship raffle and quilt raffle tomorrow during the presentation. I'll pull it and then we'll announce it at the end to save time. So if you want to buy some tickets, you can still do so. You can go to the chapter website, to the scholarship page, and there is an opportunity to purchase the tickets there. All right, any questions? I'll leave the Q&A on for a little bit if you want to, if you have questions you want us to answer right away. If not, have a lovely afternoon. It's raining out in New England, so you get a good book if you have the rest of the day off. And thank you again, Lynn, and thank you everyone for attending. Take care.
Thank you.
Bye-bye.